92 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the court's denial of my ex parte motion, asking to suspend my ex's visitation until she tells me where she resides. And this was a moment where I can very clearly remember the extreme level of frustration in the court denying my motion, because not only does the court deny the motion, but then she tries to punish me. Now, in the span of time that it took me to figure out what angle I was going to approach in filing an appeal to this order, she enters a second order where she completely changes her mind. The only thing that I can think about is that she didn't read the first order, that she just signed it. And then when she got to the omnibus motion that I filed, she woke up and read it. And then at that point in time, she decides to give me the relief that I requested in the ex parte motion, which is totally inappropriate because I hadn't requested that in the other motion that I filed. Now, even though she violated the law in my favor. So there's nothing that you can do about that. The Supreme Court will only intervene if the court's done something like that and you're aggrieved. So there are a couple of other points in time when she does this, when she violates the law, and it's favorable to me, so I can't do anything about it. But I will bring it up whenever it does happen, just so that you guys are aware of it. The best time to confront what the judge has done is when she files the order on the omnibus motion, because that's when you guys are going to be able to see what I'm talking about. At this point in time, you're just going to get to see a train wreck. But once that order on the omnibus motion comes down, then we'll be able to actually compare and contrast, and I can actually point out what doesn't make any sense at all about the process. Now, despite it not making any sense, she ends up fixing the issue, so there's nothing really that I can do about it. And we'll go into all of those details at the time that we get to the order on the omnibus motion. That's going to be 2 videos from now, so bear with me. We're still going to go through this nightmare of an order from this judge, and just keep in mind that all of the terrible things that she says in it aren't going to end up happening, because in about 9 or 10 days she ends up taking it all back anyway. So we can go into, at this point, what the judge has filed. Here we have the court's order denying ex parte motion. So the court has reviewed my ex parte motion for temporary suspension of visitation and my ex's opposition to that motion, and now finds and orders as follow. I don't know why she's entering findings of fact again. No hearing was held. So guys, this is very misleading. For the court to make findings, an evidentiary hearing has to have been held. I suppose the court can reflect on previous findings that have happened years ago, but what the court is doing here is totally inappropriate. Not only has there not been an evidentiary hearing on this issue, but my ex hasn't even filed an opposition that's verified by her affidavit. If you remember correctly, the attorney filed an opposition that was based purely on the attorney's assertions. Arguments of counsel are not evidence, nor do they establish facts. The Supreme Court has said it a million times. The attorneys and judges either don't know this or don't care. Let me correct that. The family division judges either don't know this or don't care. I don't see this issue coming up so much with non-family division judges as you see it with family division judges. Anyway, number one, the parties are the parents of a common minor child. Okay, so this is fair because this is some year-old stuff that was based on either an evidentiary hearing or a stipulation or some order from ages ago. The next assertion here, on November 13th, 2015, the court entered an order approving our mutually established parenting plan. Same thing, this is based on a stipulation, so both of us have agreed to this, so this is fine. I mean, it's not really so much a fact as it is just a procedural order that the court entered some time ago. Number 3, December 3rd, I filed an omnibus motion to establish. This is also procedure. So she's mentioning the document that I filed. She's mentioning that I repeatedly requested updated information from my ex regarding her physical residence. I claim that my ex has refused to comply with these requests. Not only do I claim it, but this has been an issue for multiple years, and this has been an issue that the Supreme Court has entered a published opinion on. So it's kind of a bigger deal than just that. Going into the next assertion, I filed an ex parte motion for temporary suspension of visitation, seeking to suspend her visitation rights. I'm alleging similar circumstances outlined in the motion. I'm alleging that she refuses to disclose her physical address prior to the scheduled visit, that she is evading requesting the information provided. You guys already seen all the email responses, so you know this is true. Basically, her position is that since she lost custody, she no longer has to give me the address. She says here that I claim that the child's welfare and safety are at stake when the parents are unaware of where the child resides. This is not just my claim. The Supreme Court of Nevada published Falcone v. Secretary of State. So not only do I claim this, but the Supreme Court claims this. Assertion number, and maybe that's where she woke up. Maybe she just thought it was just some random guy saying something, and then maybe like 8 or 9, 10 days later, she reads the other omnibus motion, she wakes up, and she's like, holy crap, this isn't just Alex, this is Justice Cherry of the Supreme Court. So anyway, once all this nonsense, we'll talk about it in a lot more detail when we get her second order. On December 30th, my ex filed an opposition. She alleges, no, she doesn't. There's no affidavit. She doesn't, this is also inappropriate. So the judge is saying that my ex alleges, pursuant to our agreement, that she was to have visitation with our minor child during a portion of Christmas break at school. She's alleging she provided me with the address for the hotel. Nope, can't do that either. And that the minor child would be staying. Nope, none of this. This is all unsupported by affidavits. So this is just the attorney claiming this for his client, which is, again, you cannot make a finding of fact on this. And then not only is it not supported by affidavit in the opposition, but we haven't even had an evidentiary hearing. So she's way out of bounds here. So none of this can be used to justify what she's trying to order, which is about to. So this just pisses me off even more. Anyway, let's continue on. We're going to talk a whole lot more about why I couldn't appeal when she enters her next order. And all of that goes into the fact that all of these things that she's about to say she's going to take back. My ex alleges that she indicated that I intend to prevent her from having visitation. Okay, so all of this. So this is the one right here where the judge overstepped her boundaries. So number 5 here, finding of fact number 5, having made a finding without an evidentiary hearing, which also could support a disqualification of the judge, as was stated by the Court of Appeals, is that when family court judges, or any judge for that matter, makes a finding of fact without having taken evidence, it's an indication of bias by the judge. So this, if you guys want to know more about the type of bias that we're seeing here, take a look at the video, self-representation bias. Because if I had an attorney, or if my ex did not have an attorney, I very strongly believe that this would not have happened. So if my ex would have filed her opposition by herself without a lawyer, or if I happened to have a lawyer, I don't think that this judge would have done this, because she would have probably been a whole lot more afraid that that lawyer would have called her out for violating the law. So sometimes when they deal with non-attorneys, they think they can get away with stuff like this. Anyway, you can watch my video on the topic self-representation bias to learn a whole lot more about why judges like this do this kind of stuff. Conclusions of law. The Supreme Court has specified a central tenet of the legal system is the concept of notice and hearing. This is a pretty generic statement, which is used when people file ex parte motions. I talk a whole lot more about this in the video Ex Parte Perils. The second assertion here, she goes into the local rule that allows the granting of an ex parte motion only in clear and grave emergencies. Imminent threat to the health, safety, and welfare of... Interesting. Let's keep on going. Number 3, with limited and unsubstantiated information provided by me, the court is unable to conclude the child's health and safety is... Okay, guys, listen to this very carefully. With the limited and unsubstantiated information, which, by the way, she's using unsubstantiated information that my ex has provided in opposition. So when my ex provides unsubstantiated information, that's okay. But when I provide unsubstantiated information, that's not okay. So this is where you can see the hypocrisy and the double standard. Attorneys get more of a break, non-attorneys get held to the rules, which is totally backwards, because the people that went to school to learn the rules are the attorneys. It makes no sense for the person that goes to school to learn the rules to be given slack on the rules, and for the non-attorney who goes into the courtroom and has no knowledge of the rules, at least no formal legal training, it's like completely backwards. Anyway, with the limited and unsubstantiated information provided by me, the court is unable to conclude that the minor child's health and safety is or was in imminent danger. Good cause appearing, my motion is not the proper subject of an ex parte order, and the motion is denied on an ex parte basis. If all of this was true, then why does she change her mind when she gets to the motion that's filed? Because the motion itself has virtually no difference if you think about it. Because when she's going to resolve my omnibus motion, nothing new is going to have occurred. There isn't going to be a hearing. There isn't going to be any new set of assertions or facts. It's going to be the exact same thing. The only thing that's different is that 10 or 11 days have elapsed from the time of this order. That's it. And here's the other problem. Somebody might claim, well, Alex, that's not true, because with a normal motion, your ex has time to respond, and she needs to have time to respond, with the whole, 10, 15 days so that she can put a proper brief in front of the court. Normally, I would say you were right, but if you've been watching this docket, you will know that her opposition has already been filed on that omnibus motion. So that's not pending. That's already been filed. So remember this when we go into the court's upcoming order two videos from now, because this specific basis here is going to be completely thrown away, and the only difference between then and now is 10 days would have passed. That's it. So the only thing that makes sense to me is the self-representation bias that I discussed earlier on in the video, and the fact that the judge most likely didn't read this. Somebody probably put it in front of her, she probably signed it, didn't read it, and then for whatever reason, she decided to read the other omnibus motion. And when she read that, she had a completely different opinion. It's like she's either got multiple personality issues or she didn't read the document. It's much more likely that this document she did not read and she just signed it. And the next document she does read, which is why you're going to see a completely different opinion come from the same exact judge. This is one of the things that I warn people about when they saw that hearing video where this judge ruled in my favor so consistently. These judges aren't our friends. One day they're ruling in your favor, and then they have amnesia, and the next time they see you, they don't have a clue who you are, and they just start entering other decisions that are completely random and make no sense. So the next decision that comes down from the judge makes a lot more sense than this decision right here. Let's continue on. The allegations prohibiting my ex from having the agreed upon visitation with her son, a violation of the current order regarding child custody and visitation of the adopted parenting plan, as well as the allegations of my ex's refusal to provide her physical address, are of concern to the court and necessitate the court's intervention. I cannot unilaterally alter the... Okay, so this is not what I'm doing. So this judge is saying that I'm trying to unilaterally alter the court's order. That's not what I'm saying. That's not what ex parte relief is. Ex parte relief is just a request for relief. It's not trying to alter the court's order. So again, if this is true, then why doesn't she mention this in the upcoming order? All of these things here, until an ex parte or other motion is ruled on, I'm required to abide by the orders in place. This is flat wrong. The point of ex parte relief is to protect a child in an emergency situation. So if this was true, if until an ex parte or other motion is ruled upon, you're required to abide by the court's orders in place. Let's say somebody says, hey, I'm going to send you an email saying that I'm about to sexually abuse our child, and you can't do anything about it until you get in the courtroom for this motion like 3 weeks from now. Absolutely ludicrous. If there's a court order in place and somebody says something like they're going to sexually abuse a child, and the court's like, nah, you have to comply with the order because you can't unilaterally change it because there's nothing pending, and no. That's the whole point of ex parte relief, aside from other things like criminal prosecution and stuff like that. So this is the judge just saying nonsense that isn't true just because she wants to use it right now at this point in time to justify what she's about to do. So sometimes you'll have issues with family court judges where they might state something that makes no sense at all, but because it supports their decision, they'll say it anyway. And this is why sometimes these judges end up sounding nonsensical. This is something that Judge Chuck Weller used to do all the time. Now you're getting to see Judge Bridget Robb do it also. Once the judge has decided they want to rule a certain way, they will find the specific things, the specific logical statements that they need to make to reach that conclusion. And I don't think that they realize it, but when they do this, they sound like they don't make any sense. Any ordinary person, sometimes it takes a legal person to actually understand what's going on, but sometimes it doesn't. Like when you look at the issues with the midnight exchanges, that was something any non-legal person could see didn't make any sense. But the judge wanted to reach a specific conclusion, which was to deny my request for relief, and so he had to say a bunch of nonsensical things to reach that point in the process. If you want to watch my video, or if you want to learn more about how this happens, watch my video on the topic, Conclusions Before the Facts, because judges do this just as often as attorneys do this too. Next section here. In the present case, I'm insisting. Oh, by the way, one more thing. So if you notice here, the judge is saying that I can't unilaterally alter the court's order, and that until an ex parte or other motion is ruled on, I'm required to comply with the order. Think about this statement here. She's saying that this motion has to be ruled on before I can get this relief. Well, when she denies this motion and she goes and she gives me the relief in the other motion that's coming up, she's violated her own statement here. Because in that other omnibus motion, I'm not asking to suspend her visits. In that motion, I'm not asking for that. So why does she give me the relief in that motion that I'm not even requesting when she's already denied the relief that I did request in this motion? In fact, if my ex had an attorney and they were savvy enough, they could have appealed that motion. They could have used against this judge her refusal to suspend visits and the fact that a written order was entered, because once that written order is entered, the judge is stuck and can't change it, with rare exceptions, and that involves due process. So the way that she did it was a total due process violation. But we're going to talk about that again. I keep on getting ahead of myself. I'm really excited to show you guys exactly how these judges do this type of stuff, and I need to wait until we get to that other order, because that's the best opportunity. In the present case, I'm insisting on obtaining my ex's physical address. This concern would hold merit except that my ex notified me of the actual place she intends to exercise visitation of the party's minor child. It's far more important for me to know where the child is rather than where she resides. So this is another thing here that convinces me that she didn't read anything, because she thinks that this is just my position. She thinks that I'm saying, hey, I want to know where my ex resides. And she doesn't realize, it hasn't dawned on her, that the justices of the Supreme Court published Falcone v. Secretary of State. So when she gets to that other motion, that's when she has her oh shit moment, and that's where she starts to break the law to fix her screw up from before. And all that happens, I think, because she actually read that document. Once her eyes pass over Falcone v. Secretary of State, a whole bunch of alarm bells are going to go off in her head, and she's going to realize that she screwed up. So that's where the instinct comes in for her to fix her screw up, and that's where all the real stuff that I want to talk about comes up. So we're going to keep on, we're going to hold on, we're going to wait. But again, guys, same thing here. If this was the case, why does this same logic not hold when the other motion gets resolved? This is yet another gaping hole in this judge's abuse of what I believe. I think it's an abuse of discretion and an abuse of the judicial process. But most of that is because of how due process works in the Constitution. And so most of that we're going to talk about when we get to that video, which is 2 videos from now. My refusal to permit visitation was pretextual and inappropriate. So here, keep this in mind, guys. Because if my refusal to permit visitation was pretextual and inappropriate, then why does she give me the relief that I'm not even requesting in that other motion? There is no difference from now and then, with the exception of the 10 or 11 days that pass between these 2 different orders. My ex shall file an affidavit within 10 days setting forth the cost of our son's airfare. I shall pay the amount to my ex within 15 days. This is what made me absolutely loathe this judge, because she doesn't even realize that she's playing right into the hands of the high conflict ex. This is what I talk about. I've said a million times before that the judges facilitate abuse and neglect, and that the judges oftentimes facilitate the high conflict child custody situation. So on many occasions, the judge will be frustrated about the high conflict, yet they will take actions, they will do things like this that actually make the situation worse. And it's one of those situations of heed what people do, not only what they say, for deeds will betray a lie. So the judges will say stuff like this, and then they'll take actions that are completely contrary to what they say. So anyway, I'm not going to be able to do anything about this for 2 reasons, because 2 orders from now, she changes her mind, and then my ex never files this affidavit anyway. So there's nothing that you can do until you're aggrieved, and I'm not going to end up being aggrieved because of the judge's actions in that next upcoming order. But you can imagine how absolutely infuriating you would be as a parent to have gone through 2 or 3 years of litigation on the residential issue, to have gone to the Supreme Court, to have been published in an opinion by the Supreme Court, to come back again after all that stuff has happened. And not only does the judge say, nah, I don't care what the Supreme Court has said, the judge adds insult to injury by forcing you to pay your ex's airfare costs. Again, this is all theoretical, guys, because I never end up having to pay it anyway, and she fixes the mistake later on. But you can imagine how, at this point in time, I would have felt. You can imagine how anybody would have felt. You can imagine why so many people absolutely despise the judiciary, the family division judiciary. It's because they do stuff like this. In my opinion, not only is it infuriating, but what she's doing is probably best described by the word cruel. Because what she's doing is she's saying, you can't protect your child, and because you tried to protect your child, now I'm going to make you pay thousands of dollars. So not only can you not protect your child, but I'm going to punish you financially for doing so. And I've used this, I use these phrases all the time, and I wonder if people really know what I'm talking about. How many times have I said on the series that the court will break your financial back if they have the opportunity to do that? That's typically how they deal with the protective parent. They don't just say, no, you can't protect your child. They say, we're also going to break your financial back to teach you a lesson so that you stop coming back to court. This all goes into the wrong-headed approach that most of the family division judiciary takes, which I discussed in the video. End of filings is not end of abuse. Now she's also saying that my ex is going to get makeup time, basically 2 days for every 1 day that she missed, and that the makeup visitation shall be enjoyed within the next 6 months. So none of this ends up happening. My ex is already gone, and she doesn't care. So this judge, here's the other thing that doesn't make any sense. The judge is taking all of these actions to protect a parent who doesn't even care. So she's basically completely and totally exposed herself professionally because she's going to start getting dinged on appeal for a person who doesn't even care. It's like the actions that the court takes to protect the abuser who doesn't even care about the judge just end up blowing up in the judge's face. It's like even the judges themselves are irrational when it comes to these kinds of cases. They don't know how to deal with high conflict child custody cases. They either don't have a clue or they are malevolent. I think that this judge just doesn't know what she's doing. She doesn't know how to do her job. But I do think that there are some judges who are malevolent. Anyway, to learn more about why this happens, please watch my video on the topic, high conflict incompetence. Going into the next section. My omnibus motion will be addressed in a separate order. So she knows about it. But what? Oh, this is even more astounding. She definitely didn't read this because she would not want to sound like the idiot that she sounds like when that other video comes out. So guys, this is all, I forgot that the judge stated that in line 7. So she knows about it. She says it's going to be addressed later. It's like, we're living in a fantasy land. This world isn't real. This is totally insane. Anyway, next section here, she says, this is standard boilerplate stuff. The law requires that all child custody orders have this provision here, which is just talking about you can't run off with the kids, blah, blah, blah. It's a crime, it's a felony, etc. A certificate of mailing under Rule 5 indicating this document was mailed to me and electronically given to my ex's attorney. Next document. Order denying motion to withdraw with leave to resubmit. So the courts reviewed her attorney's motion to withdraw, and apparently the attorney violated Rule 23. So WDCR 23 requires an affidavit with the address or the last known address at which the client can be served. So even the lawyer doesn't know where she lives. That's why, this is probably why the guy didn't include it. He probably didn't put in there her last address because he doesn't even know where she lives. Unbelievable. Next section here. The attorney has to file an affidavit. She's telling all these people to file things. Like, do your job. Like, actually do your job. Anyway, moving on. Rule 5, certificate of service indicating this document was sent to the attorney and to me. Next document, amended motion to withdraw as counsel of record. This is going to be a clone of the last motion to withdraw as counsel of record, possibly with the exception of the actual affidavit of her address. Let's take a look here. I'm just looking for that specific thing. Yeah, and it just has, this is the P.O. box that I've been using since forever. So this is nothing new. That's not useful. He's just complying with the court's order, and he's just giving me the old P.O. box that she uses. Okay. And the last document is a request for submission. Looks like he's probably just submitting the motion to withdraw as counsel of record. Uh-oh. Looks like he's referring to the wrong one, though. Filed December 14th. I think it's the wrong one. Anyway, he may figure this out later and correct it with another request for submission. He probably just didn't realize it and signed it without reading it also. Next section here, we got the affirmation pursuant to 239B. This just indicates there's no social security number. Then we got the certificate of service indicating this document was, let's see, mailed to both myself and my ex. And that's it. Going into the aftermath, I filed Nothing. So I incurred $0 in costs. My ex filed 2 documents. They were free filings, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent 5 minutes reviewing the court's order denying ex parte because he doesn't have to do anything. It's just a denial. He would have probably spent 10 minutes reading the other order and preparing his new motion and affidavit response to that. So we're looking at 15 minutes so far. And I think for him to actually prepare the document and affidavit plus the request for submission would have taken another 15 minutes at most. So we're looking at a total of 30 minutes. And that, at the rate of $250 an hour, comes to $125 in attorney fees for my ex. As my previous videos, if you have any questions, feel free to post them down in the comments below. And I will see you guys next time.